Welcome to our exploration into the source material. I'm your host, and today we're looking at something pretty foundational, your property title. The law treats it like like an absolute legal fortress.
Right. I'm your resident expert for today, and yeah, it's supposed to be the final word on who owns what.
Exactly. But even the strongest fortress has a back door. So our mission today is to unpack the legal documents you shared on the Torrens System. We need to figure out the difference between ownership and possession, how to spot extrinsic fraud, and see why the innocent purchaser for value is basically the boss of real estate law.
We've got a lot to cover. We'll be looking at the direct versus collateral attack distinction, the three major legal remedies for title disputes, and the specific clocks, the prescriptive periods you really need to watch.
Okay, so let's jump in. The Torrens title. It's not just a piece of paper. The text says it's indefeasible and incontrovertible, which is quite a mouthful.
It is a mouthful, but it basically means it's conclusive evidence of who you are and exactly what land you own. The system is built for stability.
So once you're registered, you're set.
Right. If you're buying or selling, you shouldn't have to look behind the certificate to see if there's some hidden history or a ghost owner.
A legal shield. But you can't just swing at this shield from anywhere, right? I noticed a massive distinction in the sources between a direct and a collateral attack.
Yes, that's crucial. If you want to challenge a title, you have to use a direct attack. You explicitly ask the court to nullify or cancel that specific title. What you cannot do is a collateral attack. Section 48 of the Property Registration Decree strictly prohibits that.
Meaning you can't just sneak a title challenge into a completely different case.
Exactly.
So if I'm in court for an ejectment suit, meaning someone is trying to kick me off the land,
Right.
I can't suddenly pivot and say, oh, well, I shouldn't have to leave because his title is fake anyway.
No, you can't. That's like trying to win a soccer game by complaining about the grass quality. The court wants you to play the title game on its own field, in its own separate case.
But there is one exception to this, right?
There is absolute nullity. If a title was basically born dead because it was based on a massive legal error, like a totally void judgment, then the protection never formed. In that rare case, it's fair game for both types of attack.
Okay, got it. But outside of that rare exception, your biggest enemy in a land dispute isn't just the other lawyer, it's the clock.
The ticking clock is everything in property law.
Let's talk about the remedies. Because if someone cheated you, the law gives you a strict 1-year window for a petition for review of decree, but only for extrinsic fraud.
And that distinction is vital. Extrinsic fraud is foul play before the whistle even blows. It's a scheme that happens entirely outside the courtroom.
Like a lawyer intentionally giving you the wrong trial date so you can't even show up to defend your rights.
Spot on. Because you couldn't be there, the law gives you that 1-year leeway.
Whereas intrinsic fraud, like someone lying on the stand or forging a signature used during the trial.
That doesn't count. The law assumes you were at the trial and you should have caught the lie in real time. It's a use it or lose it system.
Rough. But let's say that 1-year window slams shut. You aren't completely out of options. You still have the action for reconveyance.
Yes, which gives you a much longer 10-year window. Think of this as returning the property, not rewriting history.
You aren't saying the title is void.
Right. You're saying the title exists, but this person is holding it wrongfully, so force them to hand it back to the rightful owner.
But there's one way to beat the clock entirely. The forever option.
The action to quiet title.
Yeah. It's imprescriptible, meaning no time limit at all. But you have to be in actual peaceful possession of the land, living there, farming it, whatever.
The system really rewards the person who is actually using the land. If you're already there and someone else has a cloudy claim on paper, you can clear it up regardless of how much time has passed.
It's a great protection. But we have to talk about the ultimate limit, the game over scenario. Everything we just discussed, getting the land back, canceling the title, it all stops the second an innocent buyer enters the picture.
The innocent purchaser for value. Legally, that's where the trail ends.
So if someone stole your land through fraud, but then sold it to a buyer who had absolutely no idea about the scheme,
And they paid a fair price.
you usually cannot get that land back from them.
You can't. The Torrens system prioritizes the stability of that innocent buyer over the original owner who was defrauded. It's a tough pill to swallow, but it keeps the market predictable. It highlights that ownership isn't just a right, it's a responsibility of due diligence.
It really makes you realize that ownership is actually a race against time. The law favors the registered owner and the innocent buyer. so you have to watch those deadlines.
You definitely do.
Which brings us to a final provocative thought to leave you with as we wrap up this exploration. We often think of property as permanent. But if you found out today that your title was obtained through a clever lie 10 years ago, would you still be in time to reclaim it? Or has the innocent purchaser already locked the door behind them forever? Something to mull over. Thanks for joining this exploration.
You know, when it comes to property law here in the Philippines, there's one document that's basically king. It's supposed to be the ultimate proof, a nearly unbeatable shield of ownership. Today, we're going to break down exactly what makes the Torrens title so powerful.
I mean, think about it. How can a single certificate, just a piece of paper, carry so much legal weight that it can literally end a land dispute before it even gets started? Well, the answer is in its very design and the powerful system that stands behind it.
And here it is, the Torrens Certificate of Title. Now, this isn't just you saying you own a piece of land. This is the government itself making a declaration. It's designed to be the final word, wiping the slate clean of any other claims unless they are specifically written right there on the document.
So, to really get why this thing is like a legal fortress, we have to talk about its most important feature. And that brings us to this idea of an indefeasible title.
And these four pillars right here, this is the source of its power. Indefeasible means it can't be beaten. Incontrovertible means you can't just question it as a side issue in some other court case. It's seen as conclusive proof. And maybe most importantly, if you have the title, you have the right to possess the property. These aren't just fancy legal words. They are the very bricks and mortar of the title's strength. And look, you don't have to just take my word for it. The Supreme Court has said this time and time again. If your name is on that title, the law says you're the owner and you have the right to be there. Full stop. It is an incredibly strong position to be in.
But you know how it is in law, right? Nothing is ever truly absolute. So if this title is so powerful, how in the world can anyone challenge it if something went wrong? Like if it was obtained through fraud? This is where the rules of the game get really, really specific.
Okay, so this is the absolute key distinction. You are not allowed to challenge a Torrens title as a side issue in some other lawsuit. That's called a collateral attack, and it's a big no-no. So picture this. You're in an eviction case. You can't just suddenly stand up and say, wait a minute, I think the owner's title is fake. The law is crystal clear. If you want to attack the title, you have to file a separate case, specifically for that purpose. That's a direct attack, and it's the only proper way to do it.
And here's a perfect real-world example of that. In this Kagatai case, someone tried to do exactly what we were just talking about. They tried to attack a title on the side. The court basically slammed the door on that argument, making it clear that challenging the title has to be the main event, not a sideshow.
Now, the number one reason people launch a direct attack is because of fraud in getting the title. But the system needs finality, right? Things can't just be up in the air forever. So the law gives you a very specific, and let me tell you, a very short window to make your move.
That's it. 1 year. Once the court's decree of registration goes out, a clock starts ticking. You have exactly 1 year to file a petition to review it because of fraud. After that year is up, that title becomes incontrovertible, and that particular door is closed for good.
Okay, but now let's talk about the shield's fatal flaw, its biggest weakness. What is the problem isn't just some fraud in the process, but something so fundamentally wrong that the title was basically garbage from the moment it was created.
This, my friends, is a total game changer. We're not talking about a legitimate title that was just obtained improperly anymore. We're talking about a title that never should have existed in the first place. A document that is, in legal terms, an absolute nullity.
And here are the kinds of situations that create a void title. For example, if the government issues a title for land that, was already privately owned, it had no power to do that. Or if the court decision that led to the title was made without even telling one of the parties, a major violation of due process. In cases like these, the title isn't just flawed, it's considered void from the very start. And here is the huge takeaway. If a title is void, that 1 year clock we just talked about, it doesn't apply. An action to have it declared null and void never expires. And get this, even the rule against collateral attacks gets thrown out the window. You can challenge a void title anytime and in any relevant case.
So what happens if that 1 year window for fraud slams shut, but your land was wrongfully registered in someone else's name? Is all hope lost? Not even close. The law has this really clever remedy for this exact problem. It's called an action for reconveyance.
Now, what's so brilliant about this is how it works. Reconveyance doesn't try to break the shield. It actually respects the title as being valid and incontrovertible. Instead, it argues that the person whose name is on the title is really just holding it in trust for the true owner. So you ask the court to force them to reconvey or transfer it back to you. So here's how it plays out. Somebody wrongfully registers your land in their name. After a year, that title becomes incontrovertible. So you file a new case for reconveyance. You prove to the court that you are the actual rightful owner, and then the court orders the person on the title to sign the property back over to you. It's a fantastic way to get justice without tearing down the entire Torrens system. But you probably guessed it right, this powerful tool isn't something you can use forever. Just like with the fraud attack, the law puts a deadline on it. You have to act within a certain time frame to get your property back. And that period is 10 years. See, when land gets registered in someone else's name through fraud or mistake, the law says an implied trust is created, and the 10-year countdown for you to file for reconveyance starts ticking from the very date that wrongful title was issued. And this leads us to the final and most important twist in this whole story. There is one specific situation where that 10-year clock we just mentioned, it doesn't even start to run. What could possibly be so powerful? This is it. This is the exception. If you, the true owner, are in actual physical possession of the land, your right to get that title back never, ever expires. The law views your case differently then. It sees it as an action to quiet title. Basically, to remove the cloud that the wrongful registration has put over your property. And when you're in possession, that right is timeless. So let's wrap this all up. The Torrens title, it's designed to be this incredible shield, right? To bring certainty and an end to disputes over land ownership. But it's not absolute. Understanding its strengths, and just as importantly, knowing its weaknesses, is so crucial if you want to protect your property rights. So, what's the big takeaway for you here? It's that while your title is a powerful shield, your best defense is always going to be vigilance. That's why doing your homework before you buy a property is so critical. Checking the title's history, making sure it's authentic, and looking for any hidden claims. Knowing how to spot the cracks in that shield isn't just something for lawyers. It's essential knowledge for anyone who wants to secure their own little piece of the world.
Welcome back to the deep dive. I want you to picture something for a second. Just, visualize a piece of paper.
Yep.
Maybe it is yellowing a bit at the edges. Maybe it smells like one of those old dusty filing cabinets.
Oh, I know that smell.
Right. It has got some faded stamps on it, a heavy seal, maybe a signature that is barely legible. And on the surface, it looks incredibly mundane. It is just paperwork.
Definitely sounds mundane when you describe it like that.
Yeah.
Just another bureaucratic hoop to jump through.
Exactly. But here's the thing. In the Philippines, that specific piece of paper, the Certificate of Title, is essentially the nuclear football of property rights.
Wow.
We are talking about the Torrens system of land registration today. And our mission for this deep dive is to demystify the immense, honestly, almost terrifying power of that single document.
It is terrifying in a way. I mean, in the legal world, and honestly, just out in the real world of real estate and family inheritance, that piece of paper is often the only thing standing between you and homelessness.
Right.
Or, conversely, it is the weapon used to take everything away from someone else.
And that is the exact tension we are exploring today. We are looking at a massive stack of legal reviews, court decisions, and specifically these pre-bar materials from 2022 that define this entire system.
It is a lot of material.
It is. But the central question we are trying to answer is actually pretty simple. If you hold that paper, if your name is on that title, are you untouchable? Is that paper just a magic shield that bounces off every lawsuit, every claim, every single person knocking on your door saying, hey, that is actually my land?
The short answer to that is, well, almost. But the long answer is a very, very complicated yes, but.
And we all know how dangerous the buts can be in law.
Oh, absolutely. That but is where lives get ruined and fortunes are saved. The law is essentially trying to balance two things that do not always get along.
Stability and justice.
Exactly. On one side, you have stability. The law desperately wants that title to be final so the economy can actually function. People need to be able to buy and sell.
Right.
But on the other side, you have justice. The law wants to prevent fraud. It wants the true owner to keep their property.
And those two ideals are just constantly at war. So we're going to navigate that battleground today. We have Supreme Court rulings. We have specific case studies with some serious twists, like the Gano versus Gigato case and Amaral versus Bagumbaran.
Those are wild cases.
They really are. And we also have the opinions of legal heavyweights like Justice J.B.L. Reyes and Justice Narasa to guide us through this.
And I think it is important to point out early on that these are not just dry, boring cases.
Not at all.
These are real stories about families, betrayal, secret sales, and honestly, the brutal passage of time.
So let us jump right in. Section 1 of our breakdown. We need to define this ironclad shield. What exactly is a Torrens title? Because to me, looking at it from the outside, it just looks like a deed.
It is so much more than a deed. To really wrap your head around the Torrens title, you have to understand the legal concept of prohibitive value.
Prohibitive value, okay.
Yeah. The source material we are looking at is very, very specific about this. A Torrens Certificate of Title is conclusive evidence of ownership.
Conclusive. That is a heavy word. I mean, usually in law, things are presumed or they're arguable, right?
Right. Conclusive is basically the strongest word in the legal evidence dictionary. It means the argument is effectively over before it even begins. If your name is on that paper, you are the owner in fee simple.
Okay, stop there for a second. Fee simple. I always hear this term thrown around. It sounds like a low-cost mobile phone plan. Sign up for fee simple today. But it means the exact opposite, does it not?
It does. It has absolutely nothing to do with fees or paying for things. It means absolute ownership.
Absolute.
Yes. You own the land, you own the air above it, within reason, of course, and you own the ground below it. It is the absolute highest form of ownership in property law. And the title describing this ownership has two legal superpowers, basically.
What are they?
It is indefeasible and it is incontrovertible.
Okay, those are some serious Scrabble-winning words. Let us break them down for the listener. Indefeasible first.
Indefeasible simply means it cannot be defeated. Once that title is issued and settled, you cannot just come along and say, actually, I have a better right to this land.
So no one can trump it.
Exactly. The title wins. Period.
And incontrovertible.
It means you cannot be denied. You literally cannot argue against it in court. It is binding against the whole world.
Against the whole world. So if I have my name on that paper, the court does not just assume I am the owner. They treat it as a hard, undeniable fact, like gravity.
Precisely like gravity. And this leads to the most practical, real-world attribute of the title, which is the right to possession.
Meaning who gets to actually stand on the dirt.
Exactly. Ownership carries the right to possession. This is crucial. If you hold the Torrens title, the courts presume, and I mean strongly presume, that you have the right to be physically present on that land.
So let us paint a scenario for the listener. I go out and I buy a lot, I get the title, I drive out to the property to check it out, and I find someone camping there.
Okay.
Maybe they have built a shack. Maybe they tell me they have been living there for 10 years. What happens?
The law says, show me the title if you have it, and they do not. Well, the Philippine National Bank versus Intermediate Appellate Court case makes it crystal clear.
What did they rule?
The certificate declares the owner is free from all liens and encumbrances unless they are explicitly noted on the paper. So that squatter, generally speaking, has to pack up and leave.
No question is what the Supreme Court actually said.
No question. The title holder is the rightful owner and entitled to possession. Until that title is nullified, the holder is king of that castle.
Okay, wait. Until that title is nullified, that is the massive foreshadowing we are going to be relying on for the rest of this deep dive.
Oh, absolutely. The exceptions are where it gets interesting.
But before we get to those exceptions, let us clarify the paperwork itself. The notes mention OCT and TCT. And honestly, this is just alphabet soup to me. What is the difference?
Think of it as the life cycle of the paper. Let us start with the OCT. That is the original certificate of title. Think of it as the birth certificate of the land's registration.
The genesis of the property.
The genesis, exactly. This happens after a judicial or administrative proceeding. You go to court, you prove you own this previously unregistered land, the government agrees with you, and they issue the OCT.
Okay, making sense so far.
And Section 40 of the law says this takes effect from the exact date of entry in the registration book.
Okay. So I have the OCT. I am the very first registered owner. Now let us say I sell the land to you. Do you get my OCT?
No, I do not. The OCT gets canceled. It stays in the government archives. I get a TCT instead, a transfer certificate of title.
So the TCT is like the sequel.
It is the next link in the chain. And Section 43 is incredibly strict about this. The TCT must reference the previous certificate number. It has to explicitly say this title was derived from OCT number 1233.
It is like a blockchain,
Yes,
but made entirely of paper. You have to be able to trace it all the way back to the source.
precisely. If that chain is broken, or if a TCT magically appears that does not reference a valid previous title, that is a huge red flag. That is usually where the fraud begins.
Now, here is where the shield concept gets really interesting and honestly a little scary. The source material calls it the 1-year stronghold.
This is the bedrock of the Torrens system. It is the entire reason the system works, but it is also the exact reason it can be totally heartbreaking.
Walk me through it.
When a decree of registration is entered, so when the government officially decides to issue that OCT, there is a clock that starts ticking.
How long is the clock?
1 year.
Just 1 year.
Only 1 year. During that 1 year, the decree is vulnerable. If someone finds out about it and says, wait a minute, that is my land, he lied to the court, they can challenge it.
But once that 365th day passes,
The door slams shut.
it just slams shut.
Slams shut, locks, and welds itself completely closed. The title becomes incontrovertible. It is now binding against the whole world. Even if there was a massive flaw, after 1 year, the law prioritizes the stability of the paper over the grievance of the claimant.
That seems incredibly short. I mean, if I find out 5 years later that there was a mistake or that you somehow tricked the court, why can I not just fix it? Why on earth does the law protect the mistake?
Because of the economy.
Yeah.
I know it sounds cold, but think about it practically. If titles were open to challenge forever, if you could come back 20 or 30 years later and say, hey, there was a mistake back in 1990, nobody would ever feel safe buying land.
I see. You would never actually know if the seller owned it or if some ghost from the past was going to pop up and take your house.
Exactly. Banks would not lend money against land. Developers would refuse to build anything. You would always be looking over your shoulder.
Total paralysis.
Right. So the Torrens system says, we will give you 1 year to complain. That is your window of due process. After that, we as the society need to move on so everyone else can rely on this piece of paper.
It is a utilitarian calculus. The greater good of the economy just outweighs the individual tragedy of the person who was too slow to complain.
That is the harsh reality of it. But, as we hinted at earlier, shields can be broken, or at least dented.
Let us move to section 2 of our deep dive, breaking the shield. This section caught my eye because it sounds like military strategy. Collateral versus direct attacks.
It definitely feels like battlefield strategy, but it is really a procedural trap, and it catches a lot of people, and even some lawyers, completely off guard.
The notes say the general rule is that a title cannot be impugned, altered, changed, modified, enlarged, or diminished casually.
Right, you cannot attack a title collaterally. It absolutely must be a direct attack.
Okay, I want to pause here. Because collateral attack sounds like something from a war movie, collateral damage. But in a courtroom, it means something very specific. Can you explain this in plain English?
Sure. Imagine you are in a lawsuit for something very simple, like an ejectment case.
Okay, eject fair.
You are suing someone just to get them off the property. You are arguing about who has the right to possession right now, tonight.
Okay, so I say, get out of my house.
And the other guy says, I will not get out because, look, I have a title. Now, if you stand up in that moment and say to the judge, Your Honor, ignore his title, it is fake, it is void, just kick him out anyway, that is a collateral attack.
Why is that collateral?
Because you are attacking the validity of his title as a side issue. In a case that was filed for a completely different purpose. The case is about possession, the ejectment, but you are trying to kill the title as a shortcut.
And the courts do not like shortcuts.
They absolutely prohibit them. The Supreme Court is very clear on this. If you want to question the validity of a Torrens title, you have to file a case specifically for that purpose.
Like what?
You have to file a case to annul the title or for reconveyance. You have to put the title on the poster as the main event, not the undercard.
The sources gave a really specific example of this, and I think we need to tell this story because it shows how messy this gets in real life. The Fernandez siblings versus Telig case.
Yes, this is a perfect example of a legal train wreck.
Mm-hmm.
So picture the plaintiff, a guy named Kagatow.
Yeah.
He is convinced, absolutely convinced, that the Fernandez siblings are holding a title that should not exist.
Yeah.
He believes they are sitting on his land.
So he does the logical thing. He sues them to cancel their title.
Right. He files a complaint, essentially saying, Judge, look at their title, TCT D249437. It is a bad title. Tear it up.
Okay.
And on the surface, that looks like a direct attack. He is aiming the gun right at the Fernandez title.
So far, so good. He is suing the title holders to cancel the title. Where does he mess up?
The mess happens when they start digging into the history during the trial. It turns out the Fernandez siblings did not just conjure this title out of thin air. They bought the land from a man named Carlos, and Carlos had his own title, TCT 121509A.
So it's a chain. The Fernandez title relies entirely on the Carlos title.
Exactly, and this is where Cagetau panicked. He realized during the trial that if he really wanted to beat the Fernandez siblings, he actually had to prove that Carlos's title was bad first.
Because if Carlos was legit, the siblings are legit.
Exactly. If Carlos's title was valid, then the transfer to the Fernandez siblings was valid.
I see the problem. Is Carlos in the courtroom?
No. Carlos is nowhere to be found. He is not a defendant. He is not being sued. But Cagetau starts arguing to the judge anyway, saying, hey, we need to invalidate Carlos's title right now so I can win this case against the Fernandez siblings.
And what does the court do?
The court put up a massive stop sign immediately. They ruled that this was a prohibited collateral attack on Carlos's title.
Because Carlos wasn't there.
Right. The court basically said, you are trying to invalidate the property rights of a man who is not even here to defend himself, just as a side quest to beat the Fernandez siblings.
That feels incredibly bureaucratic, though. I mean, if the title is bad, it is bad. Why does Cagetau have to go file a whole new lawsuit just for Carlos?
Think about the due process implications. Imagine you sold a house 10 years ago. Suddenly, two strangers are fighting in court, and the judge rules your old title was fake.
Oh!
You were not even notified. You did not get to hire a lawyer.
Okay, when you put it that way, it makes total sense. You cannot strip Carlos of his rights if Carlos is not in the room.
Precisely. The Supreme Court was firm. If you want to question Carlos's title, you must file a direct action against Carlos. You cannot treat his title as a necessary incident in a fight against someone else.
So Cagetau just loses.
He loses, not necessarily because he was wrong about the fraud, but because he attacked the shield from the wrong angle.
Is there any exception to this? Because it seems like if I sue you for the land and you pull out a fake title in court, I should be able to say something right then and there.
There is a nuanced exception, and it involves counterclaims. Justice Vicente Mendoza provided some great insight here. He noted that a counterclaim can be considered a direct attack.
How does that work functionally?
Well, think about what a counterclaim actually is. You sue me for possession. I file a formal counterclaim saying, actually, I own this land, your title is void, and I'm asking the court to nullify it right now.
So the defendant basically becomes the plaintiff.
Exactly. Since the counterclaim is essentially a brand new complaint, if it specifically asks to nullify the title, the court can decide on it. Justice Mendoza reasoned that forcing the party to file a whole separate case would be needlessly circuitous.
It would just delay everything.
It would be a waste of everyone's time.
That makes perfect sense. If all the parties are there and the issue is raised directly in the legal pleadings, just settle it. Do not make us walk down the hall to file a new piece of paper.
Precisely. But there is another scenario we need to touch on here. Provisional rulings. This happens a lot in those ejectment cases we talked about. Remember, ejectment is summary. It is supposed to be incredibly fast. The judge just needs to decide who stays on the land tonight.
Right. It is not about who owns it forever. It is about who gets to sleep there tonight.
But to decide who sleeps there, the court often has to peek at the ownership question. The court might say, look, for the purpose of figuring out who has the better right to possession right now, it looks like Party A owns it.
That sounds dangerous. Does not that become res judicata? Does not that settle the ownership forever?
No, that is the absolute key. That decision is provisional. It is temporary. It is not final regarding the validity of the title. It does not bar a future case about the title itself.
So it is like a referee making a quick call just to keep the game moving, but the league review can completely change it later.
That is a perfect analogy. The ejectment court says, you stay here for now because you have the title. But a different court later on can say, actually, that title is void. Give the land back.
Okay, so we have the shield, and we have the strict rules for attacking it. But surely there are times when the shield just evaporates completely. Section 3 of our outline calls this the nuclear option.
Void judgments. This is the exception to the exception. Remember we said the title becomes incontrovertible after 1 year?
Yes. The door welds shut.
Well, that rule does not apply if the title is null and void due to a fatal infirmity. If the judgment that created the title was void, you can attack at any time, even collaterally.
What makes a judgment void? Is it just the judge being wrong about the facts?
No, being wrong is just an error of judgment. You appeal that. A void judgment is one where the court never had the power to make a decision in the first place.
Meaning what?
Usually this is about a lack of jurisdiction or a lack of due process.
Justice J.B.L. Reyes had a lot to say about this in the notes.
He did. In the case of Republic versus Buda de Calentis, he laid down the law. The principle is stunningly simple. A decision rendered without notice to the parties is void.
You cannot take my land if you did not tell me you were taking it.
Exactly. It is the ghost in the machine. If the court proceedings happened, but I was never served the summons, the court never acquired jurisdiction over my person. Justice Reyes said that acts of Congress and the executive can deny due process only under pain of nullity.
Under pain of nullity, that sounds almost biblical.
It basically means if you skip due process, everything you do afterwards is garbage.
Wow.
It does not matter if you have a fancy Torrens title with a gold seal and ribbons on it. If the original owner was not notified, that title is void ab initio.
From the beginning.
From the very beginning. It is as if the title never existed.
And there is another fascinating scenario involving private ownership here. This comes from Justice Florence Regalado. It deals with the Bureau of Lands.
The Bureau of Lands manages the public domain, right? Government land.
Yes. They can issue patents for public land, here, settler, have this plot of public forest, go farm it. But what if the land was already private property?
Wait.
What if it had been withdrawn from the public domain 50 years ago and belonged to a private family?
Then the Bureau of Lands has absolutely nothing to give.
Correct. You cannot give what you do not have. Justice Regalado argued that if the Bureau issues a patent for land that is already private, they had no jurisdiction over the subject matter whatsoever. So the title of the issue is
Void. Totally, completely void.
And the one-year rule.
Does not apply at all. An action to declare this nullity does not prescribe.
Ever.
Yeah. There's no time limit. You could come back 20 years later or 50 years later and say, this title is void because the government had no right to issue it in the first place, and the court will listen to you.
That is a massive safety net for true owners.
It is. It prevents the state from accidentally or intentionally double selling your private backyard to someone else.
Let us pivot to Section 4. We talked about the one-year rule earlier, but let us really dig into the specifics of the fraud factor. Section 32 of PD 1529.
This section allows for a petition to review the decree of registration. But as you can guess, it is highly restricted. You have to thread a very tiny needle here.
The sources list 5 specific requisites. Run us through them quickly.
First, the petitioner must have a real or dominical right, meaning you have to be the owner or have a legitimate legal interest.
Yeah.
You cannot just be a concerned citizen off the street.
Fair enough. Second?
Second, you must have been deprived of the land.
Okay.
Third, and this is the big one, the deprivation was through fraud.
Just any fraud, like they lied on a form.
No, and we will definitely get to that distinction. Fourth, the petition must be filed within 1 year of the decree.
The ticking clock.
Yep. And fifth, the property has not passed to an innocent purchaser for value.
Let us unpack the fraud part first.
Yeah.
Because the sources make a massive distinction between extrinsic and intrinsic fraud. This sounds technical, but I have a feeling it is the difference between winning your house back and living on the street.
It is the absolute difference between having a case and getting laughed out of court.
Yeah.
And honestly, it confuses even law students.
Yeah.
Let us start with intrinsic fraud. That is fraud that happens during the trial itself. Forged instruments, lying witnesses, perjury.
Wait, hold on. Let me get this straight. If I drag a witness into court and he just flat out lies to the judge's face, or if I present a forged deed, that is inside the courtroom. That is intrinsic.
Correct.
And you were telling me that is not grounds for review.
Generally speaking, no, it is not.
That is wild. The guy lied to the judge. The deed was a fake. Why does that not count as fraud to overturn the title?
Because the law says, look, you were there. You had a lawyer. You had your day in court. You had the chance to cross-examine that liar. You had the chance to hire a handwriting expert to prove the forgery. If you failed to catch the lie during the trial, you do not get a do-over.
It is a speak now or forever hold your peace situation.
Exactly. The trial was your chance to fight the fraud. We cannot keep reopening cases every single time someone says, oh, I found new proof that he lied. The courts would literally never finish a single case.
Okay, so what does count? What is actual fraud or extrinsic fraud?
Think of it as the locked room scenario. Extrinsic fraud is anything the enemy did to prevent you from even entering the room to fight in the first place.
Like literally locking me in a basement.
I mean, physically, yes, that would definitely count.
Yeah.
But usually it is subtler than that in the real world. It is deliberately failing to notify the owner of the hearing, or telling the owner, hey, do not worry about that court notice. I am just fixing a typo on my lot. I am not claiming your lot, so the owner does not file an opposition. And then they claim it anyway.
That is just diabolical.
It is. It is fraud that deprives you of your day in court. If you never got to fight, the judgment is fundamentally unfair. If you fought and lost because you were outsmarted by a liar, well, that is on you.
Yeah.
But if you were tricked into not fighting at all, that is extrinsic fraud. And that allows you to reopen the decree.
Okay, that distinction is crystal clear now. Extrinsic keeps you out of the room. Intrinsic is lying once you are already in the room.
Perfect summary.
Now let us talk about the fifth requisite, the innocent purchaser for value, or IPV. You called this the game over scenario in your notes.
It is the ultimate dead end for the original owner regarding the title itself. Even if there was fraud, even if there was extrinsic fraud, even if they physically locked you in a basement. If that fraudster sells the land to an innocent third party who pays value and acts in good faith, the remedy of reviewing the decree is completely lost.
That seems incredibly harsh. I mean, I was defrauded. I was locked in a basement, and now I cannot get my family land back just because some guy named Bob bought it.
Yes, because Bob is innocent too.
Is he?
Yes, Bob checked the title. The title said the fraudster owned it. Bob paid good, hard-earned money. If the law took the land away from Bob to give it back to you, then Bob becomes the victim of the state.
So the law actively chooses to protect the commercial transaction over the original true owner.
It protects the integrity of the Torrens system as a whole. If a buyer acts in good faith, checks the title, sees it as clean, and buys it, the law has to protect them. If the law did not do that, no one would ever buy land because you would always be afraid of some hidden fraud from 10 years ago suddenly surfacing.
So the decree remains valid to protect the innocent buyer. What is the original owner supposed to do? Just cry?
No, they are not completely out of luck. They cannot get the title back from the innocent buyer, but they can sue the fraudster for damages. They can sue for the monetary value of the land.
But the land itself, the actual physical family home,
The land is gone.
that is a bitter pill to swallow. But wait, let us look at the other side of the coin. What if the land has not been sold to an innocent buyer? What if the fraudster still has it in his name? Or what if the 1 year has passed, but I just found out? This brings us to Section 5, the remedy of reconveyance.
This is the back door. Or maybe a judo move is a better analogy. Reconveyance is a fascinating legal mechanism because it actually respects the system while simultaneously correcting the unjust result.
How does it respect the system if we are taking the land back?
Because in an action for reconveyance, you are not asking the court to reopen the decree. You're not asking them to say the Torrens title is void. You are actually looking at the fraudster and saying, okay, the law says you are the registered owner. Fine. The title is incontrovertible. I accept that reality.
You accept the power of the paper.
I accept the paper. But I say, you obtained that paper wrongfully. Therefore, in the eyes of equity, you are holding that title in trust for me. You are just a trustee.
And what does a trustee have to do?
A trustee's sole duty is to give the property to the true beneficiary. So the court orders the fraudster to transfer or reconvey the land to the rightful owner.
That is brilliant. You are not attacking the validity of the registration system itself. You are attacking the conscience of the person holding the document.
Exactly. The court admits the current holder has the legal title, but rules they are holding it wrongfully. It is a personal action against the fraudster, not an attack on the Torrens system.
What do I need to prove to get this remedy?
Just two crucial facts. One, the plaintiff is the true owner. Two, the defendant illegally dispossessed them.
And the legal basis for this judo move.
Section 102 of Act 496. It explicitly states that while registration protects against some claims, it does not insulate a fraudster from being sued by the real owner. It ensures that the Torrens system does not just become a bulletproof shield for fraud.
Now, what about timing? Do I have to wait for the decree to be completely final before I sue for reconveyance?
No. The case of Cabrera versus Court of Appeals clarified this beautifully. You do not have to wait. You can file for reconveyance as soon as the wrongful registration proceedings start.
So I do not have to sit on my hands while the injustice is actively being finalized.
Correct. In fact, in the Cabrera case, the registration was granted during the trial for the recovery of the property. The court effectively treated the pending action as one for reconveyance. Speed is very much your friend here.
Speaking of speed, or the lack thereof, let us move to Section 6. The ticking clock. This is about the prescription of actions. And this brings us to what I honestly think is the most haunting image in this entire stack of notes. We need to talk about Gano versus Shigato.
Justice Narvaez's opinion. It really is a piece of high literature disguised as a legal ruling.
The facts are just sad. You have a family that claims they were duped. They thought they were signing a paper to sell a tiny slice of land, but the paper actually sold their entire inheritance.
A classic, brutal bait and switch. And if they had run to court the next day or the next month or even the next year, they likely would have won. They would have got it back.
But they would not run. They waited.
They waited 23 years.
23 years. Why? Does the case say why they waited so long?
Life happens. Poverty, lack of education, maybe they were afraid of conflict with the buyer. But the law is incredibly cold regarding time. Justice Narvaez wrote that their right of action was eroded by time itself.
I have the quote right here. I want to read it because it chills me. He wrote, "Their right of action was erased as a sand castle on a shore is slowly and inexorably obliterated by the rising tide."
Inexorably. You cannot stop the tide.
It implies that time itself is a solvent. It just dissolves your rights.
It is the legal principle of lashes. The law aids the vigilant, not those who sleep on their rights. It sounds harsh, but think about the alternative again. If you could come back 50 years later and say, hey, my grandfather was tricked back in the day, no land title in the country would be safe, we would all be living in ghosts of past arguments.
So the sandcastle is not just poetry, it is a massive warning. If you see the water rising, meaning if you see someone else on your land or you hear a rumor about a title, you have to build the wall. You have to file the suit.
Immediately. Because once that tide covers the castle is gone forever. It does not matter how beautiful or legitimate the castle was. It is just sand again.
So what is the tide? How much time do we actually have before the sandcastle is gone?
This was a point of massive confusion for a long time in the courts. Was it 4 years? Was it 10 years? The confusion came from mixing up different types of fraud actions. But the case of Amaral versus Begumbaran finally settled it.
What is the rule?
An action for reconveyance based on implied trust, which is what the law creates when someone defrauds you, prescribes in 10 years.
Not 4, 10.
10 years. And the clock starts ticking from the exact date of issuance of the certificate of title.
Why that date? Why not the date I actually found out about the fraud?
Because the issuance of the title is considered constructive notice to the entire world. It is a public record. The law simply assumes you are checking the public records. That date is when the fraudster effectively says to the world, this is mine, not yours. That is the exact moment of repudiation.
Okay, so implied trust is 10 years. But what about an express trust?
The exception. An express trust is when I specifically agree to hold the land for you. It is not implied by law because of fraud. It is our actual agreement. Like, I will hold this land for you while you are working abroad.
Like the case of Valdez versus Olarga.
Yes. In that case, you had a lawyer, a trustee, who was handling the land for the family. He kept all the documents. He was supposed to be the protector, but he quietly transferred all the titles to himself.
Very sneaky.
Very. But the court said because this was an express trust relationship, his possession was not adverse initially. He was supposed to be holding it.
So when does the clock start for him?
Only when he unequivocally repudiates the trust and makes it known to the beneficiary.
Meaning he has to literally tell them, I am stealing this now?
Basically, yes. In the Valdez case, because he kept everything completely secret and hid the documents, the court ruled there was no effective repudiation. He never told them he was stealing it. So the prescription period had not even started yet.
That is a huge, huge distinction. If it is a secret betrayal of an express trust, the clock does not run until the betrayal is brought into the light.
Correct. But there is one more rule, the forever rule, the one rule that actually beats the sandcastle.
This sounds like magic. What is it?
This applies if the plaintiff, the true owner, is actually living on the land.
So if I am in possession, I am sleeping there, I am farming there.
If you are in physical possession and you are the true owner, your right to sue for reconveyance acts as an action to quiet title. And that action is imprescriptible.
Imprescriptible, meaning I can sue anytime.
Anytime. 20 years, 50 years, 100 years. Because your physical possession gives you a continuing right to ask the court to remove the cloud over your ownership. As long as you are standing there, you can fight to clear your name.
That feels like the ultimate justice, really. If you are actually on the land, the paper cannot displace you just because a certain amount of time passed?
Exactly. It protects the person who is physically, tangibly connected to the property. It prevents the paper tiger from eating the real farmer.
Before we wrap up, let us hit Section 7 for some final loose ends. What happens if I literally lose the actual piece of paper? The certificate gets burned in a house fire or eaten by termites. Do I lose the land?
No, this is a super common fear. But legally, losing the physical certificate does not convert the land back to unregistered land. The certificate is just the evidence. The actual registration exists securely in the books of the Register of Deeds.
So the truth is in the ledger, not in my pocket.
Correct. You just need to file for a replacement. It is an administrative hassle, but it is not fatal to your ownership.
And there was a note in the sources about admissions and pleadings. The Manorak versus Cabanaughton case.
This is about the courts not getting hung up on technicalities. Sometimes lawyers make mistakes in the complaint. They file the wrong type of case entirely.
But the court can save it.
If the defendant admits the facts, yes. If I sue you for the wrong thing procedurally, but in your answer you say, yeah, I took the land, but I had a reason, the court can look at that and say, aha, you just admitted the facts that justify reconveyance.
So the truth comes out in the wash, regardless of the typo.
Exactly. Procedural technicalities should not defeat the true owner's right if the facts are admitted on the official record.
So we have covered a massive amount of ground today. Let us synthesize the life cycle of the Torrens title for the listener.
It starts as a government grant, the OCT. It takes effect immediately. For 1 year, it is vulnerable to a review of the decree for fraud. After 1 year, it becomes indefeasible and incontrovertible. The shield goes up. However, if you were defrauded, you can use the judo move of reconveyance. You have 10 years to do this from the exact issuance of the title. But if you're actually living on the land, you have forever.
It is a system designed to lock things down, but with just enough hidden keys to open the locks if you really, really need to.
And provided you do not run into an innocent purchaser for value. That is the one lock that absolutely does not have a key.
Which brings us to our provocative thought for the day. We talked heavily about the sandcastle. The law rewards vigilance.
It really does. Ownership is not passive. You cannot just have a right, you have to actively defend it. If you let someone else register your land and you do absolutely nothing for 10 years, the law assumes you just do not care.
It makes me wonder, though. We are in the digital age now. Everything is on the blockchain or sitting in the cloud. Does this heavy reliance on a physical certificate and these incredibly strict dates of entry still make sense?
It is a great question. The Torrens system was invented when physical ledgers were literally the only technology we had to track anything. In a modern world where we could theoretically have instant, totally transparent property records, does the indefeasibility doctrine create more traps for the unwary? Does it accidentally protect the sophisticated fraudster who can manipulate the paper trail better than the simple farmer who just knows he owns the land?
A huge question for our listeners to mull over. Just because the paper says it is yours does not mean the fight is over. But if you do not fight, the tide comes in.
And the sandcastle disappears.
Thanks for joining us on this deep dive into the Torrens system. We will see you on the next one.
Stay vigilant.
Welcome to The Debate.
It's good to be here.
So, imagine you've just spent your life savings on a plot of land. You did all the due diligence, you went to the Registry of Deeds, and you walked out with that golden ticket, the Torrens Certificate of Title. It has your name on it. It's supposed to be the final word, but, well, is it? Today, we are dissecting the absolute bedrock of the Philippine property system. We are looking at the tension between indefeasibility, which is the idea that the title is an unassailable fortress, and the demands of substantive justice.
Yeah, it really is the classic clash between form and substance. On one side, you have the sanctity of the certificate, right? You have the bankers, the developers, and the economists saying that for the market to actually function, that piece of paper just has to be the end of the conversation. But then on the other side, you have the reality that a piece of paper, no matter how official it looks, can hide a lie. If a title is procured by fraud, should the law protect the fraudster just because he filed the paperwork correctly?
Right. And I am taking the hard line today. I am arguing for the fortress. Because the Torrens system fails, it completely collapses if we allow constant exceptions. For the sake of economic stability, the certificate of title must be conclusive. The indefeasibility isn't just a suggestion, it is the engine of the property market. If we start poking holes in it every time someone cries unfair, we destroy the reliability of every title in the country.
And I will argue that the law is not a suicide pact. It cannot be used to shield theft. While stability is of course important, the Supreme Court has repeatedly found mechanisms to prioritize the true owner over the holder of a mere paper title. A title is evidence of ownership, yes, but it is not a license to steal. If there is a fatal infirmity in how you got that land, the law has to have a way to claw it back.
Well, let's start with the source code of the system, so to speak. The Torrens system was designed for one specific purpose, and that was to stop the endless looking back into history. Before Torrens, you had to trace ownership back to the Spanish era, deed by deed. It was an absolute nightmare. The Torrens system says stop. Once a certificate is issued, it is evidence of an indefeasible and incontrovertible title. The Supreme Court, in cases like Abobone versus Abobone, reiterates what they call the age-old rule, which is that the person whose name is on that certificate is the owner, period. They are entitled to possession. They are entitled to eject squatters.
Sure, nobody disputes that the certificate is powerful evidence, but evidence is the key word there. It creates a presumption.
It's more than a presumption, though. It's a wall. The general rule is incredibly strict. A title cannot be subjected to a collateral attack. And this is vital for our listeners to understand because it sounds highly technical, but it's actually about keeping the lanes clear. You cannot question the validity of a title as a side issue in a different case. You have to face it head on in a direct proceeding.
Let's break that down, though, for a second. What does collateral attack actually mean in plain English?
Okay, think of it like a traffic court case. You are there because you ran a red light. The issue is simply, did you run the light? You cannot suddenly stand up and say, Your Honor, I shouldn't pay this ticket because the mayor who appointed the police chief who hired the officer who wrote the ticket was elected fraudulently.
Right.
That is a collateral attack. You are attacking the authority of the system as a side argument to your traffic ticket. The court will tell you to sit down. If you want to sue the mayor, go file a separate case against the mayor. In land terms, if I sue you to get off my property, you can't say, well, your title is void because your grandfather forged a deed in 1945.
I see the logic, but that analogy is a bit too clean. In land cases, it's usually much messier. The side issue is often the only issue that actually matters.
But the procedure matters. Look at the Cagatao case from our material. This is the perfect illustration of why we need this strict rule. You had a plaintiff, Cagatao, who filed the case for the cancellation of titles held by the Fernandez siblings. Straightforward enough, right? But during the trial, it comes out that the Fernandez siblings bought the land from a man named Carlos. Suddenly, Cagatao realizes, wait, the problem isn't the Fernandez's, the problem is Carlos's original title.
Because if the root is poisoned, the fruit is poisoned. If Carlos didn't own it, he couldn't legally sell it to the siblings.
Right. Logically, that tracks perfectly. But procedurally, Cagatao tried to attack Carlos's title right then and there inside the existing case against the Fernandez siblings, and the court said absolutely not. That is a collateral attack. You cannot broaden the scope of a trial on the fly to attack a third party's title. Carlos wasn't even a defendant in that specific hearing. If you want to question Carlos, you sue Carlos. You file a direct action. This protects the integrity of the judicial process. You can't just shoot at any title that happens to come up during a hearing.
You paint a picture of order, but I honestly see a picture of obstruction. If you cling to the Cagatao rule too tightly, you just create a bureaucratic nightmare. I want to counter with the Layson case, which was cited by Justice Vicente Mendoza. This offers a much more pragmatic view. In this scenario, the original complaint was for recovery of possession, basically get off my land. Technically, under your definition, that is not a direct attack on the title.
Exactly. So under the strict rule, the validity of the title should have been totally off limits. The court should have just looked at who had the paper and ruled on the possession aspect.
But they didn't do that. The defendant filed a counterclaim, which is basically a reverse lawsuit filed in the very same document, challenging the validity of the title and claiming ownership. And Justice Mendoza ruled that this counterclaim should be considered a direct attack. Why? Because strictly prohibiting it would cause needless circuity.
Needless circuity is just judge speak for, I don't want to do the paperwork twice.
It's judicial economy. Think about it from the perspective of the actual people involved. If all the facts are before the court, if the evidence of fraud is right there on the table and both parties are present, why force them to dismiss the case, pay new filing fees, hire their lawyers all over again, and wait another 5 years for a brand new lawsuit? That just delays justice.
The court reasoned that a counterclaim is essentially a new complaint where the defendant becomes the plaintiff. It stands on the exact same footing. So the fortress isn't nearly as impenetrable as you imply. If the challenge is properly framed within the same case, the court can and should look at the validity of the title.
I'm highly skeptical. A counterclaim is a specific legal vehicle, yes, but it's not a free pass to bypass procedure. But let's set aside the procedural how for a moment and talk about the substantive when, because this is where the fortress really lowers the gate. We have to talk about the one-year rule. Section 32 of PD 1529. This is the bedrock. It says, a decree of registration becomes incontrovertible exactly 1 year after entry.
It is a strong statute of limitations, I will grant you that.
It's far more than a statute of limitations. It's a closure mechanism. We call this the curtain principle. After 1 year, the curtain falls. The title is binding on the whole world. The material says explicitly that the decree is conclusive against all persons, whether or not they were notified, unless there was actual fraud properly litigated within that specific 1 year window. If you sleep on your rights for 365 days, the stability of the system takes precedence over your personal claim.
Whether or not they were notified. That is a truly terrifying phrase. You are effectively saying that if the court makes a mistake, or if a land grabber orchestrates a fake hearing and hands my family's land to you, and I don't happen to find out for 13 months, I lose my home?
Yes, that is the harsh reality of maintaining a reliable register. If we allowed people to wake up 20 years later and say, hey, I wasn't notified, no bank would ever lend money against land. Every single mortgage would be a gamble. The entire economy relies on the fact that after 1 year, the book is permanently closed.
I'm sorry, but I just don't buy that it is absolute. You are completely ignoring the concept of the void judgment. We have to look at Republic versus Avita. De Calantas. This case blows a massive hole right in your 1 year wall.
How so?
But the Supreme Court ruled that if the court lacked jurisdiction, or if there was a total lack of due process, like a decision rendered without notice to the actual parties of record, that judgment is void. And here's the key legal principle. A void judgment never becomes final. It doesn't matter if 1 year has passed. It doesn't matter if 50 years have passed. A void judgment is a nullity. It is treated as if it never existed at all.
But you're talking about jurisdictional defects there. That's very specific. That's when the court literally didn't have the power to hear the case in the first place.
It's not as rare as you'd hope, though. Consider the example given by Justice Regaliato regarding free patents. This happens all the time in the provinces. The Bureau of Lands issues a patent over private land that has already been withdrawn from the public domain decades ago. The Bureau has no jurisdiction over private land. They can only give away public land. If they issue a patent over your private lot, that title is void ab initio, from the very beginning. Justice Regaliato was crystal clear on this. The rule on incontrovertibility after 1 year does not apply in that situation. You cannot put a time limit on a nullity.
Okay, I will grant you the jurisdictional argument. If the court or the agency had no power, the paper is worthless. But let's look at the vast majority of cases where the court did have jurisdiction, but someone simply lied. They committed fraud. They faked a deed. This brings us to the remedy of reconveyance. You framed this earlier as a way to dismantle the title, but I would argue that reconveyance actually respects the system beautifully.
That sounds like a contradiction. How does forcing me to give up my title respect the system that gave it to me?
Because in an action for reconveyance, we are not reopening the registration's proceeding. We aren't saying the judge was wrong to issue the decree based on the evidence he saw at the time. We are admitting the decree is final. But we are arguing that because of your fraud, you hold that property in trust for the true owner.
Let's clarify that for the listeners. Reconveyance is a fancy legal word.
Sure. Think of it like asking a valet to park your car. While he has your keys, he runs down to the DMV and registers the car in his own name. Legally, on paper, he owns the car now. The DMV didn't make a mistake. They just processed the paper he gave them. But he obtained it through a massive breach of trust. Reconveyance is the court saying, okay, valet, the registration itself is valid, but you are legally obligated to transfer it back to the true owner because you are merely holding it in trust. It preserves the administrative system while correcting the unjust result.
That's a really good analogy.
But here is where your fortress theory crumbles yet again. You rely heavily on time limits, and there is a massive misconception in the legal community about the time limit for reconveyance. This is probably the most critical takeaway for anyone dealing with land disputes. Many lawyers and owners still operate under the belief that the prescription period for reconveyance is just 4 years.
Based on fraud, yes. That has been the standard interpretation in older cases like Balbin. 4 years from the discovery of the fraud, which, frankly, is plenty of time.
But that interpretation is completely outdated. The material cites Amaral versus Bagambaran to correct this exact misunderstanding. The Supreme Court clarified that the 4-year rule was based on the old Code of Civil Procedure. Under the new Civil Code, the prescriptive period for an action for reconveyance based on an implied or constructive trust is actually 10 years.
10 years. That is an absolute lifetime in the property market.
It is a significant window. The court said that when you obtain land through fraud, you create an implied trust by operation of law. And the statute of limitations for implied trust is 10 years. That gives the true owner a full decade to overturn a supposedly conclusive title. And when does that clock start ticking? It starts from the issuance of the title, because that issuance is considered the formal act of repudiating the trust. So for 10 whole years, your indefeasible title is actually quite vulnerable.
I'm not convinced vulnerable is the right word there. 10 years is a finite period. It's long, yes, but it ends. Eventually, rights must expire. This is the whole principle of prescription. Commerce requires certainty. If I buy land from you, I need to know that 20 years down the line, someone isn't going to pop up claiming an implied trust from 1985. Even the 10-year rule you cite proves my underlying point, which is that there is an end. The curtain does eventually fall. The Torrens title eventually wins.
That is a compelling argument for commerce, I'll admit. But have you considered the ultimate trump card in all of this? Possession.
Possession is distinct from ownership in the Torrens system. You can own land you've never stepped foot on. That's the beauty of modern property law. I can be sitting in Manila and own 50 hectares in Davao, and my title protects me completely.
In the abstract, yes, but in the eyes of equity, title, and possession are fused when it comes to the remedy of quieting of title. This is the absolute strongest counter-argument to your desire for absolute closure. If the true owner is in actual possession of the land, the action to reconvey or quiet title is imprescriptible.
Imprescriptible, meaning no time limit at all, ever?
None. Zero. The source material is completely explicit on this, citing the Sapto case. If a person is in undisturbed possession of their land, they have a continuing right to seek the aid of the court to determine the nature of any adverse claim.
But why? Why give them an infinite timeline? That just seems to invite laziness on the part of the property owner.
It's not laziness, it's human nature and reality. If you are living on your land, farming it, building a house on it, paying your taxes on it, you aren't checking the registry of deeds every single month. You assume everything is fine because you are physically there. The logic is that if you are in possession, you might not even know someone else has managed to secure a paper title to your lot in some faraway office. You aren't sleeping on your rights. You are actively enjoying them.
That is a terrifying prospect for a purchaser, though. It effectively means the registry of deeds isn't enough to rely on. You're saying that even if I hold the title, even if 20 years have passed, if someone is squatting on the land and claims to be the true owner, they can just take it from me?
Not squatting. Actual possession under claim of ownership. There's a big difference. And yes, exactly. The material confirms that while the statute of limitations runs against someone who is not in possession, it does not run against the actual possessor. So if a fraudster gets a title to my land, but I remain living there the whole time, I can sue him 50 years later to quiet title. In that specific scenario, the indefeasibility of his paper title is completely meaningless against the reality of my physical possession.
Look, I see the equity in that, and I admit it forces buyers to be much more diligent. It pretty much kills the idea of armchair land investing. You have to physically inspect the land to ensure no one is living there with an imprescriptible claim. But let's zoom out for a second. While you have carved out valid exceptions for void judgments and occupants in actual possession, for the rest of the world, the investors, the banks, the absent owners, the certificate is still the only thing that matters. Let's look at the consequences of losing the physical certificate itself.
What happens if the paper literally burns?
Exactly.
The material notes that the loss of the physical paper does not make the land unregistered. The right itself still exists. However, without that certificate in your hand, you are practically paralyzed. You cannot sell, you cannot mortgage, you cannot lease. The certificate is the absolute key to the economic system. While you focus on the moral exceptions, the system is built for the rule. Stability is the rule. Your points, while valid, are the exceptions. Without the strong presumption of indefeasibility, the Philippine property market would freeze overnight. The law protects the certificate to protect the public.
And I maintain that the law protects the certificate only so far as it represents the actual truth. When the certificate becomes a tool for fraud, the law steps in with reconveyance, with nullification, and with the heavy protection of possessors. I want to leave everyone with the principle from Valdez versus Olarga. The court held that a trustee cannot use the Torrens system to shield themselves from the true owner. Registration procured through fraud, shrouded in secrecy, does not constitute a valid repudiation of trust. Justice ultimately looks at who truly has the right, not just who managed to hold the paper at the end of the day. The paper can be burned, it can be lost, or it can be forged, but the rightful claim to the land remains.
It is a delicate balance. I think the material reveals that constant tension between the need for a highly reliable register, where X marks the spot and everyone can trust it, and the moral imperative to prevent legalized theft.
Precisely. And for those listening, if you are dealing with land, don't just trust the paper. Go to the site, check the possession, and if you've been defrauded, know your actual timelines. The 10-year rule from a Merrill might just save your property.
Join us next time on The Debate.
What is the probative value of a Torrens Certificate of Title?
Torrens title may be received in evidence in all Philippine courts and shall be conclusive as to all matters contained therein, principally as to the identity of the landowner, except so far as provided in the property registration decree. A Torrens certificate is evidence of indefeasible title of property in favor of the person whose name appears therein. Such holder is entitled to the possession of the property until his title is nullified. Thus, repeating that the Supreme Court has said that there is no question that the holder of a Torrens title is the rightful owner of the property thereby covered and is entitled to its possession. At any rate, it is fundamental that a certificate of title serves as evidence of an indefeasible and incontrovertible title to the property in favor of the person whose name appears therein. The title holder is entitled to all the attributes of ownership of the property, including possession. Thus, the court must uphold the age-old rule that the person who has a Torrens title over a land is entitled to its possession. Again, if a property covered by Torrens title is involved, the presumptive conclusiveness of such title should be given due weight, and in the absence of strong compelling evidence to the contrary, the holder thereof should be considered as the owner of the property in controversy until his or her title is nullified or modified in an appropriate ordinary action, particularly when the possession of the property itself is in the person's name in the title. A Torrens title is a certificate of ownership issued under the Torrens system through the Register of Deeds, naming and declaring the owner of the real property described therein, free from all liens and encumbrances except such as may be expressly noted therein or otherwise reserved by law. In Philippine National Bank versus Intermediate Appellate Court, the Supreme Court described a Torrens title as a certificate of ownership issued under the Torrens system of registration by the government through the Register of Deeds, naming and declaring the owner in fee simple of the real property described therein, free from all liens and encumbrances except such as may be noted thereon or otherwise reserved by law.
Discuss the attributes of a Torrens Certificate of Title.
As a general rule, a title once registered cannot be impugned, altered, changed, modified, enlarged, or diminished. By way of exception, a certificate of title may be assailed in a direct proceeding provided by law and not collaterally. By way of exception to the exception, a certificate of title that suffers from a fatal infirmity and is therefore an absolute nullity is susceptible to collateral attack.
When is the attack against the validity of a certificate of title considered a collateral attack?
An attack on the validity of the title is considered to be a collateral attack when in an action to obtain a different relief and as an incident of the said action, an attack is made against the judgment granting the title. Where the original complaint filed by Cagatao before the regional trial court was for cancellation of transfer certificate of title number T-249437 in the name of the Fernandez siblings and the nullification of the deeds of sale between the Fernandez siblings and spouses Fernandez and the earlier one between the latter and Almonte and Aguilar, and nowhere in the complaint did Cagatao mention that he sought to invalidate TCT number 12159-A, but it was only during the course of the proceeding when spouses Fernandez disclosed that they had purchased the property from a certain Carlos that Cagatao thought of questioning the validity of TCT number 12159-A. There is obviously a collateral attack against TCT number 12159-A. Thus, should Cagatao wish to question the ownership of the subject lot of Carlos and spouses Fernandez, he should institute a direct action before the proper courts for the cancellation or modification of the titles in the name of the latter two. He cannot do so now because it is tantamount to a collateral attack on Carlos' title, which is expressly prohibited by law and jurisprudence.
Where a court resolves the issue of ownership of land registered under the Torrens system as a necessary incident in adjudicating the issue of possession, would such adjudication of ownership be final or merely provisional?
Where the issue of ownership is inseparably linked to that of possession, adjudication of the issue on ownership is not final and binding, but merely for the purpose of resolving the issue of possession. The adjudication of the issue of ownership is only provisional and not a bar to an action between the same parties involving title to the property. Even assuming arguendo that the said titles may still be challenged, the present case, which is an ejectment case, does not provide the vehicle for that remedy, since the judicial action required is a direct and not a collateral attack. In fact, under existing law, Section 48 of the Property Registration Decree expressly provides that a certificate of title cannot be subject to collateral attack and can be altered, modified, or cancelled only in a direct proceeding in accordance with law. It was the ruling of the Supreme Court in Natalia Realty Corporation versus Judge Valles.
When is the attack against the validity of a Torrens certificate of title considered a direct attack?
An action is deemed an attack on a title when the object of the action or proceeding is to nullify the title and thus challenge the judgment pursuant to which the title was decreed. The attack is direct when the object of the action is to annul and set aside such judgment or enjoin its enforcement. On the other hand, the attack is indirect or collateral when in an action to obtain a different relief, an attack on the judgment is nevertheless made as an incident thereof.
May a direct attack against the validity of a Torrens certificate of title be made in a counterclaim filed in an action for recovery of possession?
Supreme Court, speaking through Justice Vicente Mendoza, ruled that there is no obstacle to the determination of the validity of a transfer certificate of title, even though it is true that the indefeasibility of Torrens titles cannot be collaterally attacked. In this case, the original complaint was for recovery of possession, not an original action filed to question specifically the validity of the transfer certificate of title on which the petitioner bases its right. Indeed, to rule on the issue of validity in a case for recovery of possession is tantamount to a collateral attack. However, it should not be overlooked that private respondent filed a counterclaim against the petitioner, claiming ownership over the land and seeking damages. Hence, we could rule on the question of the validity of the transfer certificate of title, for the counterclaim can be considered a direct attack on the same. A counterclaim is considered a complaint. Only this time, it is the original defendant who becomes the plaintiff. It stands on the same footing and is to be tested by the same rules as if it were an independent action. In an analogous case, the Supreme Court has ruled on the validity of a certificate of title despite the fact that the original action instituted before the lower court was a case for recovery of possession. The court reasoned that since all the facts of the case are before it, to direct the party to institute cancellation proceedings would be needlessly circuitous and would unnecessarily delay the termination of the controversy, which has already dragged on for 20 years.
When is a Torrens Certificate of Title subject to both collateral and direct attack?
A null and void judgment is susceptible to direct as well as collateral attack. Directly, a void judgment may be questioned through an action for annulment, or it may be attacked collaterally by assailing its validity in another action where it is invoked. This is because a judgment rendered by a court without jurisdiction has no binding force and effect. As explained by Justice Vito, although ordinarily a title becomes incontrovertible 1 year after it is issued pursuant to a public grant, the rule does not apply when such issuance is null and void. An action to declare the nullity of that void title does not prescribe. In fact, it is susceptible to direct as well as to collateral attack. In Republic versus Viuda de Calintas, Justice J.B.L. Reyes cited Viuda de Cuaicong versus Senbenco, where the Supreme Court ruled that a decree of registration may be reviewed not only by reason of fraud, but also for a fatal infirmity of the decision upon which the decree is based, provided no innocent purchaser for value will be prejudiced. In Viuda de Cuaicong versus Senbenco, Justice Concepcion explained, again, a decree of registration secured through fraud is valid, although annullable, upon petition filed within 1 year after the entry of the decree, in the absence of an innocent purchaser for value, whereas a decision rendered without notice to the parties of record is void for lack of due process. Indeed, acts of Congress, as well as those of the executive, can deny due process only under pain of nullity, and judicial proceedings suffering from the same flaw are subject to the same sanction, any statutory provision to the contrary notwithstanding. Justice Concepcion adds, if a decree issued in pursuance of a valid decision obtained by fraud may be annulled within 1 year from entry of the said decree, there is more reason to hold that the same, if entered in compliance with a decision suffering from a fatal infirmity for want of due process, may be reviewed, set aside, and cancelled upon petition filed within the same period, provided that no innocent purchaser for value will be injured thereby. Justice Florence Regalado applies the same principle in characterizing as an absolute nullity a pre-patent issued by the Director of Lands over private property. He said, the rule on the incontrovertibility of a certificate of title upon the expiration of 1 year after the entry of the decree, pursuant to the provisions of the Land Registration Act, does not apply where an action for the cancellation of a patent and a certificate of title issued pursuant thereto is instituted on the ground that they are null and void, because the Bureau of Lands had no jurisdiction to issue them at all. The land in question having been withdrawn from the public domain prior to the subsequent award of the patent and the grant of a certificate of title to another person. Such an action is different from a review of the decree of title on ground of fraud. Although the period of 1 year year had already elapsed from the time a certificate of title was issued pursuant to a public grant, said title does not become incontrovertible, but is null and void if the property covered thereby is originally of private ownership, and an action to annul the same does not prescribe. Moreover, since the herein petitioners are in possession of the land in dispute, an action to quiet title is imprescriptible. Their action for reconveyance, which in effect seeks to quiet title to property in one's possession, is imprescriptible. Their undisputed possession for a number of years gave them a continuing right to seek the aid of a court of equity to determine the nature of the adverse claims of a third party and the effects on her title.
What is an original certificate of title?
An original certificate of title is the first certificate of title issued in the name of the registered owner by the Register of Deeds, covering a parcel of land which had been registered by virtue of a judicial or administrative proceeding. In particular, we know from Section 40 that upon receipt by the Register of Deeds of the original and duplicate copies of the original certificate of title, which are made out in the Land Registration Authority and forwarded to the pertinent Register of Deeds, the same shall be entered in his record by the Register of Deeds, and shall be numbered, dated, signed, and sealed by the Register of Deeds with the seal of his office. Said certificate of title shall take effect upon the date of entry thereof. The Register of Deeds shall forthwith send notice by mail to the registered owner that his owner's duplicate is ready for delivery to him upon payment of legal fees.
What is a transfer certificate of title?
A transfer certificate of title is the certificate of title issued by the Register of Deeds in favor of a transferee to whom the ownership of the already registered land had been transferred by virtue of a sale or other modes of conveyance of the full ownership over the land. According to Section 43, the subsequent certificates of titles that may be issued by the Register of Deeds pursuant to any voluntary or involuntary instrument relating to the same land shall be in like form entitled Transfer Certificate of Title, and likewise issued in duplicate. The certificate shall show the number of the next previous certificate covering the same land, and also the fact that it was originally registered, giving the record number, the number of the original certificate of title, and the volume and page of the registration book in which the latter is found.
When is the earliest time possible for the filing of a petition to review or revise the decree of registration?
The petition for review contemplated in Section 32 of PD 1529 clearly envisages the issuance of a decree of registration. It presupposes the rendition, at least, of a court's decision. In fact, it has been held that a petition for review under the aforequoted provision may be filed at any time after the rendition of the court's decision and before the expiration of 1 year from the entry of the final decree of registration, where no judgment has as yet been rendered by the lower court, and much less has any decree of registration been issued. The filing of a petition for reopening and or review, therefore, would be decidedly premature. Indeed, in the absence of any decision and or decree, there is nothing to be reviewed or reopened.
What legal presumption arises where a certificate of title has long remained unchallenged since the time of its issuance?
Ching versus Malaya is a case that spoke about the effect of an unchallenged certificate of title. In this case, the property in question consisted of a residential house and lot covered by transfer certificate of title number T-85126 and registered in the name of Jose Ching in the Registry of Deeds of Laguna. The basis of the registration is a deed of sale executed in his favor by Felix Carpio, the former owner, who had acquired it from Brigido Alvarado, Cesar Alvarado's supposed father. The record does not show that such registration has been challenged since the issuance of it in 1978, which, in the absence of evidence to the contrary, should be presumed valid. There is no encumbrance on the land, and there is no adverse claim or notice of lease pendants annotated in the certificate. Such registration, it may be added, is binding against the whole world unless annulled for cause in a proper case. In Natalia Realty Corporation versus Judge Valles et al., the Supreme Court noted with approval the lower court's patient explanation that inter alia the certificates of titles issued therein in the name of the plaintiff in accordance with the Land Registration Act is indefeasible after the expiration of 1 year after the entry of the decree of registration under Section 38 thereof. Now, Section 32 of PD 1529, a petition for review of the decree of registration must be presented within 1 year after its entry. After the lapse of 1 year, the decree of registration becomes incontrovertible and is binding upon and conclusive against all persons, whether or not they were notified of or participated in the registration proceedings. So it matters that the certificates of titles of the appellee corporation were issued more than 30 years ago.
How may a decree of registration, as well as the certificate of title issued, pursuant thereto be assailed?
May be attacked on the ground of actual fraud within 1 year from the date of its entry, and such an attack must be direct and not by a collateral proceeding. The validity of the certificate of title in this regard can be thrashed out only in an action expressly filed for the purpose. According to Justice Paras, a petition for review of the decree of registration will not prosper even if filed within the 1 year period from entry of the decree if the title has passed into the hands of an innocent purchaser for value. The setting aside of the decree of registration issued in the land registration proceeding is operative only between the parties to the fraud and the parties defrauded and their previes, but not against acquirers in good faith and for value, and the successors and interests of the latter. As to them, the decree shall remain in full force and effect forever. It will be noted that the essential requisites or elements for the allowance of reopening or review of the decree are: first, that the petitioner has a real or dominical right; second, that he has been deprived thereof; third, through fraud; fourth, that the petition is filed within 1 year from the issuance of the decree; and fifth, that the property has not yet been transferred to an innocent purchaser for value. It will also be noted from the provision that any person may file the petition provided the other requisites are present, and that the provision does not require that the petitioner be an original claimant who had filed an answer, and reasonably so, because fraud might intervene precisely to prevent a person from filing an answer. Thus, a party deprived of an estate in land was accorded relief where the fraud consisted in deliberate failure to notify the party entitled to notice, or in inducing him not to oppose an application, or in misrepresentation to the true owner by the applicant of the identity of the lot, thereby causing the true owner to withdraw his opposition. Under these rulings, it follows that a petitioner for review under Section 38 of Act Number 490, now Section 32 of PD 1529, need not be an original claimant in a cadastral proceeding, and need not secure the lifting of the order of general default with respect to himself. The aim of the law in giving aggrieved parties victimized by registration proceeding of their estate in land by means of fraud the opportunity to review the decree would be defeated if such parties would be limited to those who had filed their opposition to the petition for registration, or to first require them to procure the lifting of the order of general default before they could file a petition for review.
What constitutes actual, collateral, or extrinsic fraud, and how is the same distinguished from intrinsic fraud?
Extrinsic or collateral fraud, as distinguished from intrinsic fraud, connotes any fraudulent scheme executed by a prevailing party litigant outside of the trial of a case against the defeated party or his agents, attorneys, or witnesses, whereby said defeated party is prevented from presenting fully and fairly his side of the case. But intrinsic fraud takes the form of acts of a party in a litigation during the trial trial, such as the use of forged instruments or perjured testimony, which did not affect the presentation of the case, but did prevent a fair and just determination of the case.
When would the rule on incontrovertibility of the decree of registration as well as the certificate of title issued pursuant thereto find no application despite the passage of 1 year from issuance of the decree of registration?
The rule on incontrovertibility of a certificate of title upon the expiration of 1 year from entry of the decree pursuant to the provisions of the Land Registration Act does not apply where an action for the cancellation of a patent and a certificate of title issued pursuant thereto is instituted on the ground that they are null and void because the Bureau of Lands had no jurisdiction to issue them at all. The land in question having been withdrawn from the public domain prior to the subsequent award of the patent and grant of a certificate of title to another person, such an action is different from a review of the decree of the title on the ground of fraud.
Distinguish an action for reconveyance from the remedy of reopening or revision of the decree of registration.
In an action for reconveyance, the decree of registration or patent and the certificate of title are respected as incontrovertible. What is sought instead is the transfer of the title to the property which has been wrongfully or erroneously registered in the defendant's name. All that is needed to be alleged in the complaint are two crucial facts, namely, first, that the plaintiff was the owner of the land, and second, that the defendant had illegally dispossessed him of the same. Therefore, the claimant or complainant has the burden of proving ownership over the registered land. Justice Paras had explained in Esconde versus Barlongay that an action for reconveyance is a legal and equitable remedy granted to the rightful owner of land which has been wrongfully or erroneously registered in the name of another for the purpose of compelling the latter to transfer or reconvey the land to him. The prevailing rule in this jurisdiction does not bar a landowner whose property was wrongfully or erroneously registered under the Torrens System from bringing an action after 1 year from the issuance of the decree for the reconveyance of the property in question. Such an action does not aim or purport to reopen the registration proceeding and set aside the decree of registration, but only to show that the person who secured the registration of the questioned property is not the real owner thereof. An ordinary civil action for reconveyance does not seek to set aside the decree, but respecting the decree as incontrovertible and no longer open to review, seeks to transfer or reconvey the land from the registered owner to the rightful owner.
When is the earliest time to file an action for reconveyance?
As regards the earliest date of availability of the remedy of an action for reconveyance, the Supreme Court reiterated in Cabrera versus Court of Appeals what it ruled in Agreda versus Agreda. The Supreme Court said, in Agreda versus Agreda, we held that an action for reconveyance may be filed even before the issuance of the decree of registration. There is no reason indeed why one has to wait until the land is actually registered before he can sue for reconveyance. The private respondents in this case filed their complaint because they were unwilling to recognize the registration proceedings for lack of compliance with the notification requirements. They did not have to await its termination as it happened providentially. The registration was granted during the trial of the plaintiff's complaint for recovery of the property. Hence, their pending action could conveniently and properly be deemed an action for reconveyance, filed within the 1-year reglementary period prescribed by the Land Registration Act.
May an action for reconveyance be filed to recover land erroneously or fraudulently awarded through a free patent, and if so, what limitations apply to such action?
According to Justice Hesmundo, it is settled that in an action for reconveyance, the free patent and the certificate of title are respected as incontrovertible. What is sought instead is the transfer of the title to the property which has been wrongfully or erroneously registered in defendant's name.
What are the essential requisites for an action for reconveyance?
All that is needed to be alleged in the complaint are two crucial facts, namely, first, that the plaintiff was the owner of the land, and second, that the defendant had illegally dispossessed him of the same. Therefore, the claimant or complainant has the burden of proving ownership over the registered land. Respondent, however, failed to discharge such burden in this particular case. In an action for reconveyance, what is sought instead is the transfer of the property which has been wrongfully or erroneously registered in another person's name to its rightful and legal owner, or to one with a better right.
May an opposition filed in an original land registration case be regarded as an action for reconveyance?
In Prias versus Esquivel, the petitioners complained that they be declared the owner of the lot in question was diametrically disputed by respondents who alleged that they are the only owners in common of the said lot. The nature of respondents' opposition amounts to an action for reconveyance which sufficiently vested and clothed the court below with authority to adjudicate and settle the question of ownership of the lot in dispute.
May an action for reconveyance be recognized based on the allegations of an amended complaint, particularly as deemed admitted by the answer, even if not initially alleged, in the original complaint?
In Manarpac versus Cabanatan, the case was predicated upon the allegations in the complaint, together with the admission of defendant Cabanatan in his answer, that the amended complaint is an action for reconveyance, which are deemed admitted on a motion to dismiss. There can hardly be any debate that the complaint states a sufficient cause of action for recovery of possession of the land, for settled is the rule that the remedy of the landowner whose property has been wrongfully or erroneously registered in another's name is after 1 year from the date of the decree, not to set aside the decree, but respecting the decree as incontrovertible and no longer open to review, to bring an action in an ordinary court of justice for conveyance, or if the property has passed into the hands of an innocent purchaser for value, for damages.
Discuss the justification why the law allows a person aggrieved by land registration in the name of another person to avail of the remedy of an action for reconveyance.
A person who succeeds in having a piece of real estate registered to his name is no doubt insulated by law from a number of claims and liens. There are, however, a number of instances or causes by which such insulation may be cut loose. The registered owner, for instance, is not rendered immune by the law from the claim that he is not the real owner of the land he had registered in his name. The Supreme Court had thus, in a number of cases, prescribed reconveyance of the registered land to the rightful but as yet unregistered owner. Indeed, under Section 102 of Act Number 496, after a description of the procedure to be pursued to enable a person wrongfully deprived of his land or of any interest therein as a result of the application and operation of the Land Registration Act to recover from the assurance fund the losses or damages he has sustained, states that nothing in this act shall be construed to deprive the plaintiff of any action which he may have against any person for such loss or damage or deprivation of land or any interest therein without joining the treasurer of the Philippine archipelago as a defendant therein. The Supreme Court makes this observation in the case of Prias versus Esquivel.
What is the prescriptive period for an action for reconveyance based on implied or constructive trust?
In Gicano versus Gegato, Justice Narbasa discussed the prescriptive period applicable for implied or constructive trust. In this case, he explained, the action instituted by the plaintiffs Rosa Gegato et al. Was not one to declare the deed of sale of August 23, 1952 void ab initio for lack of cause or object in accordance with Article 1409 of the Civil Code, which is really imprescriptible, but to annul it on account of fraud on the theory of constructive trust, which prescribes in 10 years. In the case at bar, Rosa Gegato and her minor children by her deceased husband, Maximo Juanico, said the children being represented by their judicial guardian, Raimundo Pundon, had executed a deed of sale and acknowledged it before a notary public, which, upon its face, transferred the entirety of Maximo Juanico's right, share, and interest interest in lot 181 to Rosa Gicano. Now, if it be true that they were deceived into executing that deed of sale by Rosa Gicano, who, taking advantage of their ignorance, had made them believe that the deed conveyed only 1/3 of the children's share in their inheritance from their father, they certainly had the right to sue Rosa Gicano, and after presenting evidence of the fraud perpetrated upon them, recover so much of the property as they had never intended to transfer and recover the damages thereby suffered by them. But they certainly did not have all the time in the world to bring that suit. They had to do it within 10 years from the issuance to Rosa Gicano of title to the property on the strength of the supposed fraudulent deed of sale. They did not file their action within this statutory period. They filed it only after 23 years. When filed, their action had already been extinguished by prescription. They had slept on their rights. Time eroded their right of action and ultimately erased it as a sandcastle on a shore is slowly and inexorably obliterated by the rising tide. In Amerol versus Bagumbaran, the Supreme Court corrected errors made in previous cases decided by it regarding the applicable prescriptive period for an action for reconveyance founded on implied or constructive trust. In this case, it said the only issue for resolution is the prescriptive period of an action for reconveyance of real property which has been wrongfully or erroneously registered under the Torrens System in another's name. In other words, what is the prescriptive period for the action to reconvey the title to real property arising from an implied or constructive trust? The petitioner herein, defendants in the trial court, assert that they had 10 years to bring the action, while the respondent plaintiff in the court below claims that the prescriptive period is 4 years. The trial court ruled for the plaintiff, now respondent, in the case before the Supreme Court. The Supreme Court reversed the trial court. It held that the prescriptive period for such an action for reconveyance as this case is 10 years. The point of reference is for the 10-year prescriptive period commences to run from the date of the issuance of the certificate of title over the real property. Amerol versus Bagumbaran went on further to explain that an action for reconveyance based on an implied or constructive trust must perforce prescribe in 10 years and not otherwise. A long line of decisions of the Supreme Court and of the very recent vintage at that illustrates this rule. Undoubtedly, it is now well settled that an action for reconveyance based on an implied or constructive trust prescribes in 10 years from the issuance of the Torrens title over the property. The only discordant note, it seems, is Balbin versus Medalla, which states that the prescriptive period for a reconveyance action is 4 years. However, these variants can be explained by the erroneous reliance on Herona versus de Guzman. But in Herona, the fraud was discovered on June 25, 1948, and Section 43, third paragraph of Act Number 190 was applied. The new civil code not coming into effect until August 30, 1950, as mentioned earlier. It must be stressed at this juncture that Article 1144 and Article 1456 are new provisions. They have no counterparts in the old civil code or in the old Code of Civil Procedure, the latter being then resorted to as legal basis of the 4-year prescriptive period for an action for reconveyance of title of real property acquired under false pretenses. In the case of Tale versus Court of Appeals, the Supreme Court mulled the same error. Here, the Court of Appeals in its question decision held that prescription bars the institution of the action for reconveyance based on fraud. Applying the rule espoused in Esconde versus Barlongay and Balbin versus Medalla that an action for reconveyance based on fraud must be filed within 4 years, the Court of Appeals ruled that the 4-year period had already expired counting from January 31, 1972, the time the original certificate of title was issued to private respondent, to August 19, 1977, the time when the complaint was filed. According to the Supreme Court, it was constrained to reverse the appellate court. Although there is no question as to when the prescription period commences, the conclusion about the 4-year prescriptive period was erroneous.
When is an action for reconveyance not subject to prescription or otherwise?
Whether an action for reconveyance prescribes or not is therefore determined by the nature of the action, that is, whether it is founded on a claim of the existence of an implied or constructive trust or one based on the existence of a void or inexistent contract. The law creates the obligation of the trustee to reconvey the property and its title in favor of the true owner, correlating Section 53, Paragraph 3 of PD 1529 and Article 1456 of the Civil Code with Article 1144, second paragraph of the Civil Code. The prescriptive period for the reconveyance of fraudulently registered real property is 10 years reckoned from the date of the issuance of the Certificate of Title. This 10-year prescriptive period begins to run from the date the adverse party repudiates the implied trust, which repudiation takes place when the adverse party registers the land. An exception to this rule is when the party seeking reconveyance based on implied or constructive trust is in actual, continuous, and peaceful possession of the property involved. Prescription does not commence to run against him because the action would be in the nature of a suit for quieting of title, an action that is imprescriptible.
What is the prescriptive period for an action to quiet title?
As a general rule, an action for quieting of title, being a real action, prescribes 30 years after accrual. However, by way of exception, an action to quiet title involving property in the possession of the plaintiff is imprescriptible.
Against whom is an action for reconveyance of wrongfully registered land available?
As long as the land wrongfully registered under the Torrens System is still in the name of the person who caused such registration, an action in personam will lie to compel him to reconvey the property to the real owner. An action for reconveyance will not prosper when the property sought to be reconveyed is in the hands of an innocent purchaser for value.
How may prescription affect an action for reconveyance of land held under an express trust?
A fiduciary relationship may exist even if the title to the property subject to the trust appears in the name of the trustee alone, because in cases of trusteeship, the legal title usually appears in the name of the trustee while the equitable titles remain with the Sestuica Trust. True it is that Torrens titles were issued in the name of Carmen Ralios in this case, but the principle holds that a trustee who takes a Torrens title in his name cannot repudiate the trust by relying on the registration, which is one of the well-known stations upon the finality of a decree of title. The finding of the Court of Appeals in this case that the issuance of titles and the execution of the purported sales and transfers, which all culminated in Attorney Soto's acquisition of titles in his name, occurred during the existence of the express trust and were shrouded by a cloud of secrecy, at least as far as Concepcion Ralios was concerned. All the papers and documents pertaining to the issuance of titles and to the transfers and sales were kept in Attorney Soto's possession and concealed from the knowledge of Concepcion Ralios. At the time Concepcion Ralios was deprived of a valuable share in the inheritance, she was kept completely in the dark. Under the facts, appellee cannot rely on the certificates of title in the names of Attorney Soto to defeat the plaintiff's right and cause of action. In Valdez et al. Versus Olarga et al., the Supreme Court, with Acting Chief Justice Macalintal as ponente, held. And from the standpoint of acquisitive prescription or prescription of ownership, this court has held in numerous decisions involving fiduciary relations, such as those occupied by a trustee with respect to the Sestuica Trust, that as a general rule, the former's possession is not adverse and therefore cannot ripen into a title by prescription. Adverse possession in such a case requires the concurrence of the following circumstances. Letter A, that the trustee has performed unequivocal acts of repudiation amounting to an ouster of the Sestuica Trust. Letter B, that such positive acts of repudiation have been made known to the Sestuica Trust. And letter C, that the evidence thereon should be clear and conclusive. In light of the foregoing doctrinal pronouncements, the Supreme Court ruled that the registration of the lots in the names of Carmen Rallos and her mother Maria Padullon, Viuda de Rallos, and their subsequent transfers and consolidation to Carmen Rallos' name alone in a manner shown to be fictitious, fraudulent, and secretive, thereby keeping the sestuis et trust in the dark, did not constitute acts of repudiation of the express trust. Such registrations were ineffective and not binding upon the sestuic trust. The Supreme Court was persuaded and convinced that the circumstances required by the decisions that it examined were not present in the case at bar.
What is the legal consequence of the loss of the certificate of title covering registered land?
The fact that the certificate of title over the registered land is lost does not convert it into unregistered land. After all, a certificate of title is merely an evidence of ownership or title over the particular property described therein.